Bonjour, mon nom est Dériva Zanon et je vous souhaite la bienvenue à cette conférence virtuelle qui s'inscrit dans le cadre des mini-conférences des jeunes chercheurs du Centre de recherche en droit public. Je coordonne ce cycle de conférences avec ma collègue Eve Gaumont qui vous présentera tantôt la conférence de nos invités du jour. Aujourd'hui, dans le cadre de cette conférence, nous accueillons deux conférencières, Madame Oana-Maria Stefanescu et Madame Chen. Je vous présenterai chacune de ces conférencières. Je commencerai par Madame Oana-Maria Stefanescu, qui est candidate au doctorat à la faculté de droit de l'université McGill. Sa thèse explore notamment les pratiques de citation entre les tribunaux nationaux et internationaux des différentes juridictions et vise notamment à déconstruire et à réinterpréter les dogmes communs sur le processus d'adjudication. Elle détient notamment une maîtrise en droit de l'université de McGill avec un accent sur l'arbitrage international en matière d'investissement et également un baccalauréat qu'elle a obtenu à l'université ouest de Timișoara en Roumanie. Madame Stefanescu, autant pour moi, est récipiendaire de plusieurs bourses et siège en tant qu'à titre de représentante Postgraduate Students Society à plusieurs comités. Quant à Madame Chen, elle est également candidate au doctorat en droit à la faculté de droit de l'université McGill et ses recherches portent essentiellement sur le droit du commerce et des investissements internationaux, l'arbitrage international et les relations internationales. Son projet de recherche examine notamment la réforme du mécanisme de règlement des différends entre investisseurs et États à travers le prisme des théories des relations internationales. Notamment, Madame Yu a obtenu une licence en droit à l'université Nankai en Chine. Elle a également travaillé comme assistante de recherche à la Commission économique et sociale des Nations Unies pour l'Asie et le Pacifique. Sans plus tarder, je laisserai la parole à ma collègue Eve Gaumont qui vous présentera le thème de leur conférence. Bonne écoute à vous. Merci.
The presentation you're about to see is about investor-state dispute settlements, or ISDS. ISDS is an instrument of public international law through which investors can sue countries for discriminatory practices. In their talk, Oana and Chen will discuss the practice of double acting, or the fact that someone acts at the same time as an adjudicator and a counsel in two separate ISDS proceedings. They will present some legitimacy concerns regarding this practice and explain their methodology for a comparative study they're conducting on this matter. I hope you'll find it really interesting. And from now on, all I have to say is enjoy.
Bonjour, my name is Oana Stefanescu and I am a doctoral candidate in law at McGill University.
Hi everyone, I'm Chen. I'm also from McGill Law.
Together we will present today an overview of our analysis on regulating the so-called double hatting issue in investor-state dispute settlement. My colleague Chen will share a PowerPoint presentation that we've prepared in a second. So, As many of you might know, over the past years, investment arbitration has been receiving a lot of criticism on all sorts of accounts, many of which stem from diverging understandings of what constitutes justice or a system of justice, how it should be guaranteed and by whom it should be delivered. For example, while the arbitrators are selected by the parties, they must also act and decide the case like independent and impartial adjudicators, much like judges do. But unlike the latter, however, arbitration is often seen as lacking the institutional means that guarantee an unbiased decision-making process, such as security of tenure. As a result, the mechanism has been undergoing a series of reform that aim to calibrate ISDS to the expectations of its users. But this has not proven to be without difficulty. So insofar as double hatting is concerned, this issue is usually understood as the practice by which one individual acts simultaneously as an adjudicator and as counsel in separate ISDS proceedings. And although the adjudicator might be in practice independent and impartial, this type of situation may nevertheless create an appearance of bias. So to exemplify, in the case of Eureka versus Poland, respondent made 2 appeals against the award. One of the arbitrator had been acting as counsel to the investor in another case, in Vivendi versus Argentina, which, although was not related in facts or in law, raised the same legal question, which was the interpretation of the fair and equitable standard. The arbitrator, when acting as counsel, invoked the Eureka award on behalf of his client against Argentina. And according to Poland, this was evidence that the arbitrator had not decided the dispute impartially, but with a view to use it as persuasive authority in his capacity as counsel. In another case, in Ghana versus Telecom Malaysia, a respondent challenged one of the arbitrators for having been serving as counsel in proceedings regarding the annulment of the award made in RFCC versus Morocco. And this was an award on which Ghana had intended to rely to build its own defense. The District Court of The Hague found that the 2 roles were incompatible, holding that in order to continue to act as arbitrator, the individual in question would have to resign as counsel in the annulment proceedings of the other case. And what I think is more interesting is that the court had also suggested that although there was no appearance of bias, double hatting is best avoided in international disputes in order to maintain the confidence in the process. So these examples stoutly point out, perception and fact are 2 entirely different things, and this makes double hatting difficult to regulate from 3 points of view. First, there is a need to define what situations constitute double hatting in ISDS, because to address an issue, one must, of course, delineate the scope of the issue, and at the moment, there is no comprehensive definition of double hatting. For some, any concurrent representation, whether as arbitrator, as counsel, as expert, creates a possible conflict of interest, and according to them, it should be prohibited entirely. While for others, they consider double hatting problematic only in certain circumstances. For example, when the facts or the parties are related in one way or the other. The second problem relates to identifying whose concerns regarding the issue ought to be addressed. And here there is the question of how the parties view double hatting in the context of a particular dispute. But there's also the question of how non-parties assess the independence and impartiality of adjudicators whenever an award is made public. And it must be said that neither of these categories is homogeneous. So whatever solution is proposed or adopted, it must be done so with the understanding that it cannot be a one-size-fits-all solution. Lastly, there is the problem of deciding how to address these concerns and to what extent. And a central question in the proposals for reform that Chen and I have been reviewing, most notably the ICSID and New Central Draft Code of Conduct, So a central question in these works is whether double hatting should be prohibited as a matter of law, or whether it should be left to the parties to decide on the acceptability of this kind of situation in their case. And both options have advantages and disadvantages. For example, on one hand, the prohibition eliminates the issue altogether, but it could also narrow the existing pool of arbitrators and have a negative impact in terms of diversity, if we assume that most individuals prefer the role of counsel. A smaller pool of arbitrators also increases the risk of repeat appointments, which usually creates an appearance of bias as well. On the other hand, leaving it up to the parties to decide preserves their autonomy, and party autonomy is the main feature, or it constitutes the main appeal of ISDS, but this does not make a significant change otherwise in terms of the appearance of bias with respect to double hatting. So with this, I conclude a brief introduction into our topic, and I yield the floor to my colleague Chen, who will elaborate on why double hatting is an issue from a legitimacy perspective and detail the other aspects of our project. Thank you.
Thanks very much, Oana, for the excellent introduction. So I will be talking about the legitimacy concerns. To understand how to regulate double hatting, it is firstly very important to understand what types of legitimacy problems has been caused by or are related to the issue of double hatting. So the most fundamental reason why double hatting has attracted much attention in the discourse of ISDS reform is that it impairs the perception of independence and impartiality of investment arbitration. So as a famous arbitrator, Philip Sands questions, it is hard to imagine that somebody who acts as arbitrator drafting a word in the morning can keep a neutral mind while he works in the afternoon as a counsel for his client on a quite similar issue he was dealing in the morning. Such doubts on the impartiality of the arbitrator impair not only the disputing parties' conception of fairness, but more importantly, it impairs the confidence of the public on the legitimacy of the system. So adjudicators' failure to psychologically keep neutral while switching minds between different roles is more of a problem of issue conflict, because they may have this inappropriate predisposition when dealing with similar subject matters. And the problem can become much more complicated when it is intertwined with the potential conflict of interest arising from the arbitrator's previous practice as counsel for one of the disputing parties. Actually, the problem of the issue conflict, as you can see in this slide, has been drafted separately in Article 5 of the Draft Code of Conduct. But in Article 6, which is on the issue what we are talking about today, double hatting, it actually also noticed that the risk arising from previous professional practices, because it mentioned that if you read the second line, the person should avoid to act on matters that involve the same parties. So it makes the issue of regulating double hatting more complicated, because actually Article 5 and Article 6 inevitably overlaps to a certain extent. And apart from the issue conflicts and conflicts arising from interest, a third problem often discussed relating to double hatting is diversity of the community of investment arbitrators. So empirical study has shown that double hatching is practiced so inconsistently by a highly visible and powerful call of some of the most influential actors in the system. So I was quoting the very famous paper by Longford, Ben, and Lee about the revolving door phenomenon in international investment law. So those arbitrators, most of whom are from the rich north, have formed a closely connected network that may exert considerable influence on investment lawmaking through investment arbitration. Although the fact that the homogeneous background of these core arbitrators does not necessarily lead to the conclusion that their decisions are biased against the states, especially developing states, it may well give rise to concerns that the values and the voices of developing countries are underrepresented in the whole arbitration system. And on the other hand, of course, it has been argued that arbitral institutions are indeed actively seeking to appoint some new arbitrators, but it is actually the parties who refuse to appoint newer arbitrators. So these issues has made the regulation of double hatching even more complicated, and we believe that all of them must be addressed in the code of conduct. And next, I would just like to give you a brief introduction about our research methodology. As indicated by the title of our paper, it's a comparative study. So here I quote a sentence written by Rees in his paper, How to Do Comparative Law. He mentioned that comparative method consists in focusing careful attention on the similarities and the differences among the legal systems being compared, but in assessing the significance of differences, the comparatist needs to take account of the possibility of functional equivalence. So to us, it means that to explore solutions to a particular legal problem through comparison. So here in the context of our paper is the problem of double hatching. It is not sufficient to simply compare the similarities and differences of legal rules and procedures between those various legal regimes. Rather, we must pay attention to the institutional context. For example, the purpose, the function, and structure of the institution. And we need to understand how these rules, the relevant rules and the procedures are designed according to this institutional context. And for the purpose of this paper, it means that we will not simply compare the double hatching related rules in different regimes, but we will carefully examine how these rules fit into their institutional features. To this end, we look into a broad range of adjudication mechanisms, from public ones such as the European Court of Human Rights and the WTO, the World Trade Organization, to private ones like commercial arbitration. We will also look into some domestic practices. And this legal regimes vary in terms of disputing parties, the nature of disputes, adjudicator appointment methods, adjudicator remuneration schemes. And after a preliminary examination of the relevant rules, we decide to divide them into three categories. The first category includes legal regimes that are dominated by a high degree of party autonomy. A typical example you can imagine is commercial arbitration. And the second category refers to legal regimes that are on the other end of the spectrum, where adjudicative bodies enjoy a rather high degree of judicial independence. For example, the European Court of Human Rights. And the third category generally covers legal regimes that stand in the middle of the spectrum, where a balance is being struck between party autonomy and judicial independence. A typical example is the WTO, which specifies different rules for the panel proceedings and appellate body proceedings. The ultimate purpose of our comparison, of course, is not to find which category investment arbitration falls into, because it is obvious that investment arbitration is a mixed form. It falls between party autonomy and judicial independence. So our task is to identify which institutional features are relevant to delineating double hatching rules and how they should be weighed and balanced for the purpose of drafting the code of conduct. So we must admit that our program is very much an ongoing one. Our preliminary aims are to firstly delineate the scope of double hatching, and also we seek to find a more balanced approach that considers other actors such as investors and the public, and more from a legitimacy perspective. And we will also evaluate the effects and the consequences of prohibiting versus allowing the parties to decide on the issue of arbitrator appointment. We will welcome any comments and suggestions. Thank you.